My name is Heath Davis, and I'm the Managing Attorney here at Wirth Law Office. I wanted to take the opportunity to explain to you what the divorce process in Oklahoma looks like from beginning to end. A case is begun by one party filing what we call initial pleadings. Those initial pleadings typically consist of a petition for dissolution of marriage and an application for temporary orders. Once those are filed with the court clerk then issues what's called an automatic temporary injunction and a summons. The summons allows us to serve the other party with those documents. Once that party is served, they then have 20 days to file a formal response to the court. If you fail to file a formal response within that 20 days, you're at risk of a default judgment being entered against you by the judge. Once that's done, the court sets what's called a parenting plan conference. Prior to that parenting plan conference, the court asks that the parties exchange financial disclosures, what we commonly refer to as DR5 documents. At the time of the parenting plan conference, the judge will come out and briefly explain to you what the process looks like and what they expect. Some of those expectations include watching a video and doing a parenting course that is required prior to a final decree ever being entered. The judge then strongly encourages each party and attempts to help the parties enter into an agreed temporary order at the time of the PPC. If an agreed temporary order can't be entered, the court then gives us a referral to the district court judge, who will then hold a hearing on the temporary orders and put those in place. Once a temporary order is entered, the parties then typically enter into what we call the discovery process. The discovery process has three components to it. One is interrogatories. Interrogatories are simply questions that each party asks the other. The second is request for production of documents. That simply is exactly what it sounds like, each party requesting documents from the other party. Third is request for admissions. These are simply questions where you either admit or deny the truthfulness of each question. Once that's done, if depositions are needed, then that will be the next stage prior to a final hearing being entered. Most judges in Tulsa County require that prior to a final trial being set, that the parties attend mediation. Mediation is typically set and the parties go and again try to reach a final agreed order so that a trial is not necessary. If that can't happen at the time of mediation, then that final trial is set and the parties will go before the judge, and the judge will enter final orders with regards to custody, property division, and debt division. Once that order is entered, the parties are then granted their divorce and they go their separate ways.